Welcome to In the Public Interest from WilmerHale, an international law firm at the intersection of government, technology, and business. Thank you for joining us. I'm Felicia Ellsworth.
And I'm Michael Dawson. Today's episode is the latest installment in our second annual Supreme Court miniseries, where we dive into the most hotly contested decisions coming out of the Supreme Court this term and discuss the implications of the court's rulings going forward. On this episode, we will be discussing the court's recent decision in Cantero v. Bank of America, which concerns the scope of states' authority to regulate national banks and the standard for showing that a state law is preempted under the National Banking Act. Joining me to discuss this case is Julie Williams, Senior Counsel in WilmerHale's Washington, D.C. office. Julie is a leading authority on bank and financial services regulation, having served as Chief Counsel and first Senior Deputy Comptroller of the Office of the Comptroller of the Currency, the OCC, one of the nation's primary banking regulators, where Julie served for 2 decades. Thank you so much, Julie, for joining us on this episode on our Supreme Court miniseries.
Michael, thank you. This is great. Great to do.
Let's start with some factual background. Could you say a little word about who the parties were in the case and what the dispute was about?
Sure. The parties were a borrower, Mr. Cantero, and the bank lender, B of A. And the issue was around whether Bank of America was required to pay interest on the escrow account that was required to be set up in connection with the mortgage. An escrow account is an account that is typically set up in connection with taking out a mortgage. The borrower pays a certain amount each month into the escrow account, which the bank then uses to pay taxes and insurance. It assures the payment of taxes and insurance. And so the question was whether the bank was required by a New York law to pay at least 2% interest on that account. Bank of America argued that the New York law couldn't force it to pay interest because Bank of America was a federally chartered bank and New York State couldn't tell a federally chartered bank what to do under the National Banking Act.
Tell us a little bit about that. What is it and why does it matter?
Well, national banking was created shortly after the Civil War. It's a national banking system. It is a system that exists alongside of the system of bank regulation that the states have. And national banks derive their powers and primarily are regulated by federal agencies, in contrast with state-chartered banks, which derive their powers from state law and are primarily regulated at the state level. And so you have 2 parallel banking systems, and that's what's referred to as the dual banking system that the U.S. has. Under constitutional principles of supremacy, where you have a conflict between a federal authority and a state restriction, the federal authority wins, and that's the supremacy clause. And here, the federal law were the powers granted to national banks under the National Bank Act.
So how does someone know whether a state law is preempted under the National Banking Act? What's the standard for preemption? Is it absolute conflict? The two have to be at odds, or is it something else?
Well, that is actually a great question and was at the heart of the Cantero case. Many state laws where there have been questions about preemption over recent years, at least, have been state consumer protection laws. And the issue around preemption of state consumer protection laws was, do they interfere to some meaningful extent with the powers of national banks to do certain things that the banks are authorized to do? The area was very contentious, and ultimately Congress waded in with the Dodd-Frank Act in 2010 and promulgated some standards for determining when a state consumer financial law is preempted. I drop a footnote here. This is state consumer financial law. It's not other types of state law that were addressed in Dodd-Frank. And just to make things a little bit more complicated, Dodd-Frank actually had 3 standards for preemption of state consumer financial laws. One was if the state law discriminated against national banks compared to state banks, treatment of state banks. Another was if the state law significantly interfered, as the Supreme Court had discussed in a very important case called Barnett, if there was a significant interference with a national bank power. And then thirdly was if the state law was preempted under some other federal law, and there's a complicated issues of citation that relates to, but there are actually three standards of preemption that Congress adopted in Dodd-Frank to run alongside with whatever standards of preemption are applicable when you're not talking about a state consumer financial law.
And so in this case, in Cantero, it sounds like it's a consumer protection case. We've got a consumer wants a mortgage, has to pay money into an escrow account, and New York State says, hey, banks, you've got to pay interest on that escrow account. And the argument of the bank is that that state consumer protection law impinges on a power granted it under the National Banking Act and therefore should be preempted. How did the court, the district level, at the Second Circuit Court of Appeals level, think about that question? And what did they get right? What did they get wrong? What did the Supreme Court do about it?
Well, I'll tell you the punchline here is that according to the Supreme Court, both of the courts of appeals that had looked at this got it wrong. In the Cantero case, which was in the Second Circuit, the Second Circuit basically applied a preemption standard that a state law couldn't control any aspect of how a national bank exercised its powers. So a very generous preemption standard. There was another case that had arisen out in California that had dealt with the requirement to pay interest on mortgage escrow accounts, which required the payment of at least 2% of interest on mortgage escrow, very same type of law as in Cantero. And in the Ninth Circuit, the circuit court concluded that California state law was not preempted because it wasn't punitive or severe enough to really interfere with the bank's ability to do business.
So one court of appeals is applying a control test, and the other one is applying an interference test.
A control test and a type of interference test, yes.
And they both got it wrong?
According to the Supreme Court, they both got it wrong. The Cantero decision was about the Second Circuit decision, where the Second Circuit took a position that this is the control test, which the Supreme Court in Cantero said basically under that test, everything, just about everything would be preempted. And that's not the Barnett test that's referred to in the Dodd-Frank law. And then about 10 days later, the Supreme Court remanded back to the Ninth Circuit, another case. This is the one that the court had found the same type of state law not preempted, and said that one was wrong too, and they both needed to be reconsidered in accordance with the standards in the Supreme Court's Cantero decision, which looked to the standards in a previous Supreme Court decision, which is Barnett.
And both of these were unanimous decisions by the Supreme Court remanding.
Remanding, yeah.
How could these circuit courts each get the case wrong in a way that was so clear to a unanimous Supreme Court? How could they get it so wrong?
Well, they picked the wrong elements of the Supreme Court's earlier Barnett case to focus on. I think perhaps in the Ninth Circuit, there may have been some, I want to say, political or public policy consideration driving the result. I wouldn't say that for the Second Circuit. The Second Circuit just took a very generous approach to the circumstances where you could find preemption. And the Supreme Court said, do over both of them.
And so where are we now? What is the standard? Is it a bright line or is it something more nuanced?
It's not a bright line. The banking industry would have liked the Second Circuit's control test because very few state laws would have survived under that test. Where we are, ironically, is back to the case law that preceded Dodd-Frank, which gave rise to all of this kerfluffle, and the jurisprudence that has developed over literally 150 years in construing national bank preemption and looking at some of the key cases that preceded the Cantero decision that the Supreme Court specifically pointed to. It was like, look at this case, look at that case, look at what we did there, look at the level of interference that we found sufficient or insufficient to find preemption. It's back to the future. It rolls back the clock on the standards to be applied going forward, but these are not new standards. They're the standards that have been litigated for decades.
Interesting. Now, some critics of the opinion argue that they want bright lines, and they argue that the court has provided too little guidance on how to apply the preemption standard. Do you agree with that criticism?
I think that the court did not provide the bright line that some wanted, but the court was very clear on the standards to look to. And it's a nuanced analysis that's required, but it's not a new or unproven type of analysis to apply. There's plenty of history and precedent behind it.
Now, you were in the OCC when Congress considered and passed the Dodd-Frank legislation. At the time, what did the OCC think was the right standard? What did you advocate for?
I have to chuckle here, Michael, because the decision of the Supreme Court in Cantero in how to read the Dodd-Frank language was exactly the way we thought it should be read and what we advocated.
Why does this preemption doctrine matter to the economy, to consumers? Why is it important?
The doctrine of preemption in finance today is way more than just an interesting historical relic. As you think about how financial products and services are delivered, how the banking business is conducted, it does not operate according to state lines. With the technology, the way of communicating back and forth with customers, the way of delivering products, the extent to which so many banking products and services are really information-based, the ability to do business in multiple jurisdictions under a single recognized source of powers and consistent oversight of those powers, for the most part, by one federal bank regulatory agency. Preemption becomes even more important as the business of banking evolves with the use of technology.
Hmm. Now, when you were at the OCC, unlike some other federal agencies, had independent litigation authority. Could you talk a little bit about that and what it was like to exercise that, maybe specifically on preemption type questions? And if you can talk a little bit about your journey on preemption up through the courts, up to and including the Supreme Court.
Well, the OCC does have independent litigating authority and has filed amicus briefs on a number of topics within many decades. One of the topics that the OCC has filed a number of amicus briefs on is preemption, or preemption cases. And the agency has thought over the years that preemption is a really fundamental characteristic and benefit of the National Bank Charter and felt a responsibility to defend it. And so at the OCC, the agency filed many amicus briefs at the district court level and at the Court of Appeals level. The OCC does not have independent litigating authority before the Supreme Court. When the cases would go to the Supreme Court, the Solicitor General's office would represent. I would note, up until this Cantero case, that was always a very harmonious relationship. And at the OCC, we got tremendous support from the SG's office in Supreme Court arguments. Cantero was different.
How so?
The SG's office decided that they had a better view about how to apply the Dodd-Frank provisions and put in an amicus brief that was not in accord with the positions that the OCC had been taking for the last number of decades.
Interesting. So the Solicitor General's office essentially changed the way it was arguing these cases in Cantero.
That's correct.
And why did they do that?
I think it was probably something that was driven by policy considerations.
Meaning?
A preference to have more state consumer protection laws rather than fewer state consumer protection laws apply to national banks.
What else is important for us to know about this decision?
Well, I think what's important is what's next, because the case goes back to the Second Circuit, case goes back to the Ninth Circuit, and to your point about implications for administrative dimensions, at the very, very end of the Cantero decision, there's a footnote that says that the parties may wish to raise the relevance, if any, of the OCC's preemption regulations, which was not something raised in the case in its first time through.
What's an example of a preemption regulation?
Well, an example of a preemption regulation is state laws dealing with escrow requirements are preempted. Absolutely on point.
Well, thank you very much, Julie. It's been a pleasure and very interesting discussion. Thank you for appearing on In the Public Interest.
Thank you, Michael. This is fun.
Thank you, everyone listening, for tuning in to this episode of In the Public Interest. We hope you'll join us for our next episode. If you enjoyed this podcast, please take a minute to share with a friend and subscribe, rate, and review us wherever you listen to your podcasts. If you have any questions regarding this episode, please email them to us at inthepublicinterest@WilmerHale.com.
For our WilmerHale alumni in the audience, thank you for listening. We are really proud of our extended community, including alumni in government, the nonprofit space, academia, other firms, and leadership positions in corporations around the world. If you haven't already, please join our recently launched Alumni Center at alumni.wilmerhale.com so we can stay better connected. Our show today was produced by RP Yusufian, with sound engineering and editing by Brian Beninati, and additional support from Emily Freeman, Peter Taransik, Ambi Budram, and the rest of the WilmerHale podcast team, all under the leadership of executive producers Sydney Warren and Jake Burnell. Thank you for listening.
See you next time on In the Public Interest.